I call the Senate Housing and Homelessness Prevention Committee to order. There is a quorum present. Today we are hearing 6 bills, all of which will be voted on and sent to their next committee step. The first 5 bills will be voted on to move to judiciary, and the last bill will go to HHS. Please keep in mind that we will likely not have time today to answer all questions, but there's plenty of time in between committee steps to work with bill authors on their bills. We have a tight timeline today. Testifiers will need to keep your remarks to 2 minutes, and I'll ask that members keep the discussions to specifics relevant to this committee, understanding that there will be judiciary and HHS specific time in those committees as well. The first item on the agenda is Senator Boldon's bill, Senate File 3553. Welcome to the presenter's desk, Senator Boldon. I believe you have an A1 amendment.
Yes, Madam Chair, I would move the A1 amendment.
A1 is Senator Boldon's author's amendment. Any questions? Yes. All in favor of the author's amendment, say aye. Aye. Opposed? The amendment is adopted. Senator Boldon, please present your bill as amended.
Thank you, Madam Chair and committee members. It is good to be before you this afternoon. This is a technical bill that corrects some errors made in several sections of law amended in last year's Judiciary and Public Safety Bill and makes one clarification in existing law. You'll see that sections 1, 3, and 4 just correct errors. And Section 2 addresses a problem for lawyers that tenants have too frequently encountered regarding confusion around some landlords with respect to late fees that can be charged to subsidized housing tenants. It's long settled practice and common law that late fees are applicable to the tenant's portion of rent only, not the entire rent. And this section just codifies what we all agree is the intent of the law. I want to thank the Minnesota Multi-Housing Association with whom we worked on this bill, and I have legal experts available to answer any questions, and I ask for member support.
Thank you, Senator Boldon. I believe we have some testifiers today. Ron Elwood, you are first on the list. Mr. Elwood, please introduce yourself for the record and proceed with your testimony.
Thank you, Madam Chair. Members, Ron Elwood with Legal Aid. Really don't have much to add other than to thank Senator Boldon for carrying this bill. And I just want to reiterate our thanks to the Minnesota Multi-Housing Association for working closely with us on this bill. Thank you.
Thank you, Mr. Elwood. Ms. Zwack, please introduce yourself for the record and proceed with your testimony.
Thank you. Julia Zwack. I'm a managing attorney at Mid-Minnesota Legal Aid, the housing unit in our Minneapolis office. I would just echo Ron Elwood's comments and thank Senator Boldon for carrying this bill forward. We look forward to working on this as it moves forward, but don't have anything further to add.
Thank you very much. Members, on to questions. Senator Lucero.
Thank you, Madam Chair. And I guess I just want to confirm that the verbiage on line 1.9 of striking expiration and inserting execution was not changed by the amendment. So that retains, correct?
Senator Boldon.
Thank you, Madam Chair. Senator Lucero, yes, that is correct.
Senator Lucero.
Thank you, Madam Chair. Okay, then to the Senate author. So by changing the word expiration to execution, it will then read that a landlord must wait 6 months from the execution of the current lease before requiring the tenant to renew the lease. So the question I would have is, if I have to wait as a housing provider, I have to wait 6 months, so I could have a tenant, I regularly have my tenants enter into 24 or 36-month leases. So 6 months into a 24-month lease, by changing the word expiration to execution, I could then require them to now sign the lease, which is still 18 months into the future. Is that correct?
Senator Boldon.
Thank you, Madam Chair. And I'll let our legal experts weigh in here too, but I want to just clarify the intention of this section. So as it previously stated, this is a correction. A landlord must wait until 6 months from the expiration of the current lease. So what it was saying is, 6 months after a lease expires, they could renew it. Clearly, that was an error. It makes no sense to renew a lease after it expires. So this is reverting to the initial intent of having opportunity for that early renewal of lease, having it be 6 months from the execution of the current lease versus after it expires, which makes no sense. And I'll turn to our other legal experts to add anything to that if they would like to.
Please introduce yourself for the record and go ahead and respond.
Thank you, Chair Port. My name is Shana Temenis. I am a staff attorney at the University of Minnesota Student Legal Service. Along with the University of Minnesota's undergrad student government, we helped with the first bill that is now, thank you very much for the correction. Senator Lucero, I agree with you that the language and the problem with 6 months into a 2-year lease would be problematic. I think that the goal of the bill is that there is an adequate time in the relationship before a renewal is required, or it could cause an unfair power imbalance. So whether to the extent that it's to the last 6 months of the lease or 6 months into a lease, we don't have a strong opinion on it. In our industry, what was happening was around Dinkytown, it was 15 days into a 12-month lease. So that really getting anywhere in that 6-month period of some knowledge is beneficial. I'm not sure if that helps this committee. I apologize.
Thank you, Ms. Jimenez. Senator Lucero?
Thank you, Madam Chair. Okay, so what I just heard then is that the change that is being proposed before us, if I understood correctly, you're admitting is problematic because it's going to allow for an 18-month lease, a 24-month lease, again, 36-month lease. Multiple of my tenants have that. I, as a housing provider, could force that 6 months into a brand new lease. I guess what I would suggest, and I don't know why you can either answer it or not, why would you not leave the word expiration as it is and instead change the word until to within? So it would read, a landlord must wait until within 6 months. Or must wait within 6 months from the expiration. In other words, they can't force a renewal of the lease until they're within 6 months of the expiration of the current lease.
Senator Boldon.
Thank you, Madam Chair. And I'll also just say I'm happy to continue the conversation with you, Senator Lucero, to get to a place where this language, happy to continue conversation. I would just say also that this language doesn't, it would prevent landlords from requiring renewal within the first 6 months of a lease, but it doesn't require them to do so at 6 months. So if you would like, to wait longer, you are able to do that.
Senator Lucero?
Thank you, Madam Chair. Okay, well, just want to understand what the intent is, want to understand what you're going to allow then. So if this language becomes law, whether or not a housing provider chooses to do so, you are allowing them to require a tenant renew a lease that's still yet 18 months, or hypothetically 18 months into the future. So, okay, thank you.
Members, other questions? All right, Senator Boldon, do you have a motion to move your bill?
Yes, Madam Chair. I would make a motion for Senate File 3553 as amended to be recommended to pass and be re-referred to judiciary.
Perfect. Members, all in favor, say aye. Aye. Opposed? The ayes have it. Senator Boldon, your bill is moved on to judiciary. Thank you very much.
Thank you, Madam Chair.
We are waiting for some members who are presenting in other committees, but I think I saw Senator Gustafson. Is that right? Yeah. Senator Gustafson, we'll move to your bill, Senate File 3748. And Senator Gustafson, I believe you have an author's amendment.
I do. Thank you, Madam Chair. I believe you have a copy of it, but I would like to move that it be added so we can get the bill in the shape we need it to be in.
Senator Boldon moves the A1 amendment. All in favor, say aye. Aye. Opposed? The amendment is adopted. Senator Gustafson, please present your bill as amended.
Thank you, Madam Chair, members of the committee. Senate File 3748 amends current law that provides critical right of a survivor of domestic violence to break their lease when their safety is jeopardized. It makes important improvements and clarifications in the law to make it more usable for the survivors of domestic violence for whom it was intended. The underlying statute, Section 504B.206, was enacted in 2007 in collaboration with the Minnesota Multi-Housing Association and again with MHA's partnership tweaked in 2013. In the years since, domestic violence advocates have found gaps and obstacles in the law that this bill seeks to address. First, the current law requires a survivor who breaks the lease to provide notice of the date the lease will terminate, but often survivors need to flee prior to the date given in the notice.
I'm sorry to interrupt, Senator Gustafson. Just to let members around the table know, the A1 is being printed and delivered to you. Go ahead, Senator Gustafson.
Sure. Thank you. First, the current law requires a survivor who breaks the lease to provide notice of the date the lease will terminate, but often survivors need to flee prior to the date given in the notice. There is also confusion as to whether the date of termination is the date provided in the notice or the date when the survivor is forced to vacate the premises. Section 2 of the bill clarifies that the termination date is the date provided in the notice. Second, domestic violence advocates have too often seen cases where even though the survivor followed the law to a T, the survivor is still named in the eviction filing. Section 5 of the bill clarifies that a survivor cannot be the subject of an eviction filing if the survivor met the requirements of the statute. In working with Multi-Housing Association, we also clarify that nothing would prevent the filing of an eviction if a survivor remains beyond the termination date and no longer has the legal right of possession. Third, when this bill was passed in 2007 and amended in 2013, the concept of having a medical appointment over Zoom or Teams was unheard of. Things have changed since then. One of the requirements of the statute is that a person seeking to exercise their right must meet with and obtain from a third party professional certification that there is a need to break the lease. However, the law does not recognize that such a meeting might be virtual. Section 6 of the bill clears that up. Fourth, the bill includes a penalty for violation of the prohibition on revealing information about the survivor to the abuser or any other tenants on the lease. While we recognize the penalty is high, it is set at a high amount because of the consequences of a prohibited revelation of this information can be dire or worse, deadly. Finally, I want to note that this bill is supported by Standpoint, Violence Free Minnesota, MnCASA, and Legal Aid. And I want to thank Minnesota Multi-Housing Association for working closely with us to craft the bill that's before you. And so I ask for your support. Thank you.
Thank you, Senator Gustafson. And on the testifiers list, I have Mr. Elwood. Please introduce yourself again for the record and proceed with your testimony.
Thank you, Madam Chair. Ron Elwood with Legal Aid. And I really want to thank Senator Gustafson for carrying this bill. As you probably know, I mean, she has really stepped up to be a champion for victim survivors in Minnesota, and we're really grateful, so grateful for her advocacy in this arena. And I want to thank our partners, the Violence Free Minnesota, Standpoint, and MnCASA for working with us. And once again, really express our strong appreciation for the Minnesota Multi-Housing Association. We spent a lot of hours working on this bill, and we really appreciate their collaboration and partnership. Thank you. Happy to stand for questions.
Members, questions? All right. Senator Boldon, would you move this? Senator
Madam
Housley.
Chair, you're going to move it, but I'm just wanted to ask if we could roll call the final passage and have it placed in the journal.
Yes.
Thank you.
Senator Boldon, would you move the bill?
So moved, Madam Chair.
Yeah, as amended.
As amended.
There will be a roll call. Roll call has been requested, roll call granted. The clerk will take the roll.
Chair Port,
Aye.
Vice Chair Boldon,
Aye.
Senator Draheim,
Aye.
Senator Housley,
Aye.
Senator Lucero,
Aye.
Senator Pa,
Aye.
Senator Zhang,
Aye.
Senator Mohamed.
With 8 ayes and 0 noes, your bill is passed as amended and sent to judiciary. Thank you very much.
Thank you, everybody. Appreciate it.
Next up, we will go to Senator Mohamed's bill, Senate File 3587. Senator Mohamed, welcome. You have Senate File 3587 in front of us today. I don't believe you have an author's amendment, is that correct?
No.
You can go ahead and present your bill then.
Thank you, Madam Chair, members of the committee. I'm hoping this is a very simple bill. Senate File 3587 clarifies existing statutes. It would require landlords who require additional fees for renters with pets to list in their lease that service animals are exempt from required deposits or additional pet rent. This bill seeks to protect renters with disabilities and all renters who may or may not understand their tenant rights under existing statute. Service animals have been exempt from additional deposits or fees for years in Minnesota, and this bill will clarify the statute and proactively protect the renters in Minnesota. This bill also provides an enforcement mechanism to allow tenants to recover fees paid if their landlord did not provide disclosure in their lease. So I'll take questions. Thank you, Madam Chair.
Thank you, Senator Mohamed. I have Jennifer Spadine on the testifiers list. If you would please introduce yourself for the record and go ahead with your testimony.
My name is Jennifer, Madam Chair, member of the committee, my name is Jennifer Spadini. I own and operate a property management company housing people throughout the entire Twin Cities area. I'm here today on behalf of the Minnesota Multi-Housing Association to raise our concerns about the precedents of SF 3587 ESA disclosure. We are concerned that this proposal would set a precedent for other statutes where we are already prohibited from doing something under state or federal law, but then must provide a disclosure. Are we going to be required to disclose that we are not allowed to leave pest infestations unaddressed, or that we are not allowed to operate an unlicensed property? Continuing this trend across the statutes would create extensive policy disclosures, which may overwhelm our residents as they consider a lease and its terms. Importantly, our new residents already feel overwhelmed by the amount of information we affirmatively disclose, such as the rights and responsibilities of all parties. The more information we add, the more it dilutes the significance of the most essential disclosures. Thank you, Madam Chair and members of the committee, for the opportunity to provide these concerns.
Thank you, Ms. Spadini. Members, questions? Senator Lucero.
Thank you, Madam Chair. And to the bill author, do you have, what is your intention for the enactment date?
Senator Mohamed.
I think we have, as the bill passes, so end of, what's that typically? We don't have end of session, I don't know, whenever the bill passes.
Senator Lucero?
Thank you, Madam Chair. So then, if I write a lease with that intention, if I sign a new lease with a new tenant the day after a session, is that your expectation?
My expectation is any time, Madam Chair. Senator Lucero, my expectation is any lease that will be signed after the bill passes, then we have to make it clear that this is sort of the law.
And my understanding, Senator Lucero, is that bills that don't have an enactment date go into effect on August 1st. So that would be the point at which it would go into effect. Senator Lucero?
Thank you, Madam Chair, and that is my understanding as well, but that's not what the bill author said. So that's why if it's the day after it's signed into law, is it August 1st? That was the reason for the question, but I understand it sounds like it's the day after it's law is the intention.
We, Madam Chair, Senator Lucero, will put on there August 1st, just to make it standard.
Okay. Then the next question would be, I guess, pertaining to, maybe it's more of a comment, but I think that brings up a really good point, the testifier, that the amount of disclosures that continue to happen, are beginning to really stack up, and it's going to become a stack of paper like this. One of the things that I do is I have homes that are pre-1979, so I give the realtors disclosure for lead, for example, and that lead disclosure is like 24 pages, something like that. And you add all the other disclosures on top of that. My lease by itself is, I think, 18-ish pages, and you're going to continue to have and this is just going to make the lease itself, if you're requiring this to be in the lease, to be even longer. So you're getting to a point where it's been in my experience when buying and selling homes, the amount of paperwork that has to be signed at closing by a buyer is just overwhelming. They don't read anything. They're just signing. They're just signing, dozens and dozens of pages. And I see a similar effect happening here, is that there's going to be this mountain of disclosures, especially with some of the other bills that are coming after this, that are just going to overwhelm prospective tenants. And I'm not sure that this is actually going to bring added value as Madam Chair, that the bill author is seeking. So just something to be cognizant of, because there's a lot of prohibitions that housing providers have now, as the testifier said. Why are you calling out this one specifically? It's already against the law. Why are we calling this out? Why not any of the other things? Again, rhetorical question, but thank you, Madam Chair.
Senator Mohamed?
Thank you, Madam Chair. Senator Lucero, I think those are really good points. And I think the intent of it is to not make harder for tenants to be able to read these leases. I think right now, this is obviously our current law. It's not clear when, it's not required for landlords to put it into their leases, which has brought cases where folks are paying when they shouldn't be, right? I think over the years, our lease has, I will be bringing an example of a lease on Thursday to sort of show the pages of leases when people are signing these leases, how big they are. And what I've actually discovered is in that lease, majority, every single page is almost to protect the landlord, never to protect the tenant. And so part of the tenant laws that we're doing this year is to make it fair for both tenants and for the landlords. And so our lease also has to show that as well. And so this is just a small fraction to say, our law says this, therefore you don't have to pay, especially for folks who are currently living with disability and other things who need these service animals.
Senator Boldon?
Thank you, Madam Chair. And I don't have a question, but just a brief comment. Thank you, Senator Mohamed, for bringing this bill. The effect of this is that it will reduce barriers for Minnesotans with disabilities. As we're talking about, who this will affect, Minnesotans with service animals. Especially this will be impactful. We know Minnesotans, people with disabilities, are at higher risk for homelessness and housing instability. And so I think everything that we can do to sort of put protections and to lower those barriers to be sure that we are, as much as possible, keeping people with disabilities housed, I think is the right thing to do. So thank you.
Senator Draheim?
Thank you, Chair. And thank the author for bringing this bill forward. I understand the intent of what you're trying to do here, but I think it is kind of redundant. And, you know, for someone that looks at paper all day long up here in the Senate, in the real estate industry, that's all we see is form after form after form after form. And there is something to be said about diluting what you're showing clients, or in this case, a tenant or prospective tenant. You know, what is the definition of the disclosure going to be? You know, a lot of forms that a lot of us use, and I'm not suggesting this in this case, are done through the Realtor Association, and they're vetted. A lot of time and energy is spent on them. What is going to be disclosure requirement? And who's going to decide what that is or what it isn't? So I think this needs a little more work if we're going to see this at the end of the year. I don't disagree with the concept that, yes, we need to make sure tenants know what they're signing and what they're getting into. I think we all agree on that. But I don't think this is the right way to approach it. So I hope we can have some discussion maybe offline and see if we can tighten this up a little bit. So thank you.
Senator Mohamed?
Thank you, Madam Chair. Thank you, Senator Durham. Definitely would love to talk and sort of get your perspective on what you're thinking.
Members, any final questions? Senator Boldon moves that Senate File 3587 be recommended to pass and referred to the Committee on Judiciary and Public Safety. All in favor say aye. Aye. Opposed? The motion prevails. Senator Mohamed, your bill is on the way. Thank you. Senator Putnam. Senate File 3769. Welcome to the committee, Senator Putnam. Go ahead with your presentation.
Thank you, Madam Chair and members. I think this is my first time getting to hang out with you guys in the Housing Committee, so I appreciate the opportunity to visit with you. This bill is actually extremely simple and pretty straightforward, so I don't want to take up too much of your time with my initial description of it. This bill is super simple, but the potential is to have a great and positive impact on everyday Minnesotan renters and landlords. The bill would prohibit discrimination in rental applications from tenants who do not have a Social Security number if they have an ITIN number. You might be asking, though, what's an ITIN number? It's a fair question. An ITIN number was created to help individuals comply with U.S. tax laws and to provide a means to process and account for tax returns and payments for those not eligible for Social Security numbers. For example, in the past year, 23,000 people in Minnesota filed their taxes using an ITIN number. They're issued regardless of immigration status because both resident and non-resident aliens may have a U.S. filing or reporting requirement under the Internal Revenue Code. Think international students. Like, by happy accident, a bunch of my friends from St. Cloud are here with us in the room today. Many of them are international students. And when they heard that I was presenting this bill, they wanted to be here to hear it. Because they know of the struggle of some international students to find housing. They come here oftentimes to avail themselves of the great opportunities and education that Minnesota has to offer, and then they have to struggle to find a place to live. This takes care of that problem pretty easily. An ITIN number does not authorize work in the United States or provide eligibility for Social Security benefits. It just helps people pay their taxes, and it helps identify them in a certain sense. And a friend of mine told me recently that there's a Honda dealership that has a big sign that they accept ITIN numbers to buy a car. We're talking not about any kind of credit reference because those credit checks are still going to be accounted for. All we're talking about is increasing opportunities for renters to rent and for landlords to have a new population to rent to. So landlords can and likely will still require credit checks and can make decisions they want based on the results of that credit check. So this change will help some folks find a place to live, but will also explicitly enable landlords to consider a new population of tenants. So Madam Chair, thank you for your consideration, and members, thanks for taking the time to think about this important issue.
Thank you very much for bringing this bill, Senator Putnam, and welcome to all of your friends from St. Cloud. You have some testifiers. First on the list, I have Irma Marquez Tro. Welcome to the committee. Please introduce yourself for the record and present your testimony.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Irma Marquez Tro, and I am the CEO of Latino Lead. At Latino Lead, we envision a world where Latinx community members are civically engaged, connected and supported, and seen as a vital voice of influence in Minnesota. I want to start by thanking Chair Putnam for his work and leadership in supporting Minnesota families and for chief authoring this bill. I am here today to support SF 3769 because housing is one of the largest and highly impactful necessities in life. And this proposal ensures that all of us have access to the same opportunities with rental housing. I mentioned that we work with a network of Latino leaders, professionals, and businesses. So in addition to this being a call for more equitable housing practices, I'm also here to voice support for this proposal on behalf of our cross-sector network. One of our network members is Paramount Residential Mortgage Group, or PRMG for short. They would like to have been here, but were unable to be here in person today, so I am going to read their letter in support. This on behalf of Clinton Rooney, who is the area manager for Paramount Residential Mortgage Group. He is also the founder in Starfish Home Group, and I'll just read what the letter in his point of view shares. I am writing this statement in support of SF 3769 to ensure that Minnesotans use ITIN can access a dignified rental housing options. Starfish Home Group's goal is to help the underserved population with their housing needs by lowering the barriers of entry. Our goal is to provide safe and dignified housing to all tenants we serve. We have been in service in Minnesota for 7 years. One of our business divisions is rental properties. We have about 41 rental units and serve approximately 27 families in Minnesota. We have adopted the practice of accepting the ITIN as part of a rental application process for 5 years as a strategy to increase pool of people that could fill our rental units. This has been a smart and profitable business strategy for our company's division, and we encourage others to do the same. Rental housing is a great option for people who currently cannot afford to purchase a home, or folks that simply do not want to deal with the responsibilities of homeownership. This proposal makes perfect sense for housing justice and business perspectives. Our company will continue to accept rental applications that use ITIN numbers, and I urge members of this committee to vote in favor of SF 3769. So as you can see, this is a great proposal that has the support of the immigrant population, advocates, and the business community. Thank you so much, and I urge all of you members of this committee to please support this critical proposal. Thank you so much.
Thank you for your testimony. Next on the list, I have Juan Luis Rivera Reyes, and after that will be Ryan Perez. Welcome to the committee. Please introduce yourself for the record and provide your testimony.
Hello, Chair Port, Vice Chair Boldon, and members of the committee. My name is Swan Luas. I'm a coalition organizer with the Alliance for Metropolitan Stability, a local nonprofit, and also a member of the Equity in Place Coalition. I want to thank Senator Putnam for championing this bill, Senate File 3769. I am speaking in support of this bill as a son of an immigrant, and recognize that all Minnesotans should be able to participate freely within our economy and recognize their rights to safe and dignified housing. More specifically, I grew up in a mixed status household. Being a child of immigrants, I know firsthand the difficulties our communities face when trying to exercise their desire to be full participating members of our society. As a child, I experienced housing instability for every year up until high school, where my family would move every year, sometimes twice within the same school year. Every single time it was due to the rising cost of rents and the limited options of housing that we had available to us. Finding other suitable housing and moving due to those challenges, became even more challenging. Without an ITIN, my parents were not able to establish a line of credit and substitute their ITIN in place of a Social Security card or a Social Security number. The lack of ITIN forced us to live in tight conditions with other relatives. It caused us to move states a few times, and it caused us, as a result of those mental and emotional traumas that we still live with to this day. To this day, as a grown adult, the lack of ITIN and the actions that my family had to take in order to maintain a roof over our head has had deep impacts in my life, from navigating and establishing my own credit to navigating the rental market that did not show me the best growing up. The lack of ITIN forces families like mine to live in the shadows and in suboptimal conditions. We know this is not the desire for many families, as we want to be able to freely and legally participate in our society and economy. Thank you for your time and consideration. I, as an individual, and Equity in Place as a coalition of BIPOC nonprofit organizations, look forward to seeing Senate File 3769 advance, and for tenants in the state of Minnesota to have a more equitable housing system that would allow for us to continue to move towards a true equity and stability for all Minnesotans.
Thank you very much, Mr. Rivera-Reyes. Ryan Perez. Welcome to the committee. Please introduce yourself for the record and provide your testimony.
Ryan Perez, R-Y-A-N-P-E-R-E-Z. Hello, Chair Port and members of the committee. My name is Ryan Perez, and I'm the organizing director at Copal, Minnesota. Copal is a member-based organization aimed at improving the quality of life for Latina Minnesotans. I'm speaking today as a member of the One Economy for Minnesota campaign, where we dream of a Minnesota where ITIN holders and all Minnesotans can participate as equals in the state's economy. This results in healthier, safer, and more stable communities for all those who call this place home. Our campaign is based out of Mankato, St. Peter, and Medalia, Minnesota, places where working Latin American families have made home since the betabeleros, the beat workers, who arrived in the early 20th century. In these towns, we are engaged in an educational campaign, organizing not only with ITIN holders, but also business owners and managers that seek to build a more inclusive Minnesota. Since we launched our campaign in the fall, we have already identified several major property management companies in the Mankato Region 9 area who have or plan to update their applications. They will accept ITIN numbers as an equal alternative to the Social Security number for rental applications. One such company is Atwood Management, one of the oldest family-owned and operated management companies in all of Minnesota, with properties ranging from New Ulm to St. Peter, Waseca to Rochester. After making our case to include the ITIN option to Rachel, the property manager, she realized the change was just good business sense. Of course, Atwood wanted to open the door to more clients. In making this change, Rachel quickly realized the data system they were using already had a one-click toggle option on the back end of the database to accept ITIN numbers, because national data infrastructure was already built for the realities of the market. Now Rachel expresses to us a desire to increase Atwood's Spanish language staff capacity, further boosting their economic prospects. As we continue to educate property management companies about ITINs, we find much excitement in opening up new markets and building a more inclusive economy. I ask you to pass this bill through committee for the benefit of all Minnesotans. Thank you.
Thank you very much, Mr. Perez. And finally, on the testifiers list, I have Joe Abraham. Welcome to the committee. Please introduce yourself for the record and present your testimony.
Thank you, Madam Chair, members of the committee. Good afternoon. My name is Joe Abraham, and I've been a housing provider in Minnesota for 25 years. I currently own and operate 650 apartments. These are naturally occurring affordable housing. So if you make 55 to 60% of the median income in that area, you're spending less than a third of your income on rent in our buildings. I believe this type of well-maintained affordable housing is critical and in short supply. It's my hope that elected officials agree and enact policy that increases access without dramatic unintended consequences on cost. I'm here today to provide testimony on Senate File 3769, the proposal allowing individual taxpayer identification numbers as alternative to Social Security numbers for rental housing applications. According to the IRS, ITINs do not serve a purpose other than for federal tax reporting. Credit agencies do not use ITINs, and they're not generally associated with an individual's credit or housing history. I want our buildings full, and with decades of experience, I believe I've set screening standards so that We are setting up residents for success in their new homes, not financial strain or financial ruin. I also believe I have an obligation to our current residents to know the creditworthiness and the history of others in the buildings. And why do I believe this is true? 94 cents of every dollar of rent paid covers our operating expenses and our mortgage. New residents without a demonstrated ability to pay earn a financial risk, and the cost of that risk is always borne by others living in the building. Our industry is already facing a crisis of fraudulent applications, and I believe our inability to verify important and accurate credit information will further strain our expenses and therefore the cost of housing. Thank you, Madam Chair and members of the committee, for the opportunity to testify today.
Thank you for your testimony. I will start. Senator Putnam, I want to thank you for bringing this bill. I'm carrying a similar bill that allows for utilities as well to be gotten through ITIN numbers. Our immigrant community is one of the strengths of Minnesota. We have powerful relationships throughout our communities. And the more access that we can give for folks to live full, regular lives here in Minnesota, and housing is at the core of that. So I'm really grateful for you bringing this bill. I look forward to moving it. I appreciate everyone who is willing to come and testify as well. And we'll go to member questions. Senator Lucero.
Thank you, Madam Chair, but my question was for the last testifier, if he could come back up. Thank you, sir. So in your testimony, you had a line something to the effect of the cost of those unable to pay is borne by the rest of the tenants. Is that, would it be accurate to say then that's another way of saying rents are higher on everybody else who is paying as a result of those who are not paying?
Yeah, Madam Chair and Senator Lucero, yes, that's correct.
Mr. Abraham.
I'm sorry?
Go ahead, Mr. Abraham.
Oh, I apologize. Sorry about that. Madam Chair, Senator Lucero. So yes, all these costs, everything that happens in these buildings get borne by the property. So in this case, when you have some sort of fraud, when you have someone that leaves an apartment, when you have any type of issue in the building, those costs go back into the building. I mean, it's no different than any other product or any other service that's out there. And so we really try to do our best to minimize those costs. Doesn't matter if it has to do with a service provider or, in this case, a policy change that would put people at risk of being in the wrong housing. We say it all the time. We want a match. We want to house everyone. We don't want our apartments empty. No one does. We want to fill them up, but we want to evaluate people and put them in the right circumstances so they can succeed and have a really nice home, and we can keep the building that they're in as affordable as possible. So we believe that this type of thing will prevent us from doing the screening that we have and keeping people in the right place, and therefore the cost down for the entire building.
Senator Lucero.
Thank you, Madam Chair, and that's all I had for you. Thank you. I think that's an important piece of testimony to keep in mind, that we are in a time right now where costs have skyrocketed, the cost of housing. And if this policy is going to potentially result in a greater risk, a greater degree of uncertainty, that can only be mitigated by raising the rents. That's the opposite direction I think that Minnesota wants us to go. The next question, Madam Chair, to the bill author is, does an ITIN, as we heard testimony here, does an ITIN allow for, or is it used to track credit history or criminal history?
Senator Putnam.
Thank you, Madam Chair. Thank you, Senator Lucero. First, if I may, go back to your earlier comments in reference to the earlier testifier. Risk is not consequence. Those aren't the same thing. So to say that there's increased risk does not mean that there is increased expense. So that's one point, just initially. But secondly, I would say, in terms of your question about the ITIN itself, the ITIN is just for identification. Landlords are still perfectly allowed, eligible, encouraged to do their own credit checks. The ITIN has nothing to do with tracking credit specifically, because that's what the credit check is for. The ITIN issue is just for identification of an individual. And this creates more opportunities for more individuals to be eligible for more housing. But equally important, I think we need to acknowledge that I think there's probably a great deal of lack of clarity on what an ITIN is, even in this room, maybe among landlords as well. So this is an opportunity to make it clear that there is a new population that they can rent to who are perfectly reliable. And I will object strenuously to any insinuation in this room that people who have ITINs are automatically less reliable at paying their rent. That's an unacceptable and unjustified assumption because the credit check is separate from the ITIN, as a sort of roundabout way to answer your question, Senator Lucero.
Senator Lucero?
Thank you, Madam Chair. Well, okay, we're going to go back and forth now to what you said earlier, the risk is not an expense. That's not reality. That's not the way the real world works. Whether you're getting a loan from a financial institution for any reason, that interest rate, in part, is influenced by the potential, the risk of default. And the lesser the risk, the lesser the interest rate, and hence the cost that's passed on to that who's paying. So as you increase, you just made a statement that risk is not expense.
That's actually,
that is not true. Because if there's increased risk, as a housing provider, I and any others cannot tell the future and therefore can only mitigate or compensate by increasing the cost for the potential of an increased risk of default or an empty unit. So the next question I would have then, as you just said, Madam Chair, Senator Putnam, that an ITIN is used for identification purposes. Could you please explain the process? How is a credit check performed in the absence of a Social Security number?
Senator Putnam.
Madam Chair, Senator Lucero, just a quick point of clarification. Doesn't obviate your point to any extent, but what I said was risk is not consequence, not risk is not expense. I said risk is not consequence, and that there's a difference between the potentiality of something happening and having it already happened. That was the point that I was making. Now, in terms of your question about how an ITIN actually works relative to a credit check, I'll be honest, I don't know. I'm not a landlord. I don't know how credit checks work especially well. But I do know that our neighbors and our landlords deserve an opportunity to rent to people who don't have a particular piece of information in terms of a Social Security number. 23,000 people in the state of Minnesota this year are people who will now have a greater opportunity to rent in a space that's most helpful for them. So again, I apologize for my ignorance in terms of I don't know how credit checks works. I'm not a landlord. But I do know that we have people who need an opportunity to be able to rent the place that works for them. And that's all this does, because it doesn't get in the way of a credit check in any way, shape, or form.
Senator Lucero?
Well, thank you, Madam Chair. So you're submitting a proposal here that is going to require that a housing provider accept an ITIN in place of a Social Security number. And as the housing providers that have to implement this, they are going to want to know, how do they achieve a credit check? And how am I, as a member of this committee, and any member of this committee, supposed to make a decision on supporting this or not if you, as the bill author proposing this change, don't even know then how a credit check is performed in the absence of the requirement of a Social Security number? And I would have a similar question to the criminal history. And so we need to know how this is going to be applied in law to verify the criminal history that can threaten. If we can't have a sufficient criminal history, that potentially threatens other tenants in the building. We right now are in a time where people are very cognizant of their safety and security. And I, as a housing provider, want to know that I'm not bringing in somebody dangerous that might threaten my fellow tenants. Similarly, I need to have confidence that that person is going to be able to pay, because I don't want to put the burden on those who are paying by increasing their rent. And if you don't know, Madam Chair, if the bill author doesn't know, I'm very concerned about any way that we could support this. The last question I would have, Madam Chair, for the bill author, is it possible, I had to wait there so you could hear the question.
Sorry about
Can
that,
a person who has a Social Security number now, this is my unfamiliarity, can they apply for and get an ITIN number as well?
Senator Putnam.
Madam Chair, Senator, I apologize for that brief conversation there. We do have someone here who does know perhaps the dynamics of how this
Please.
works. Senator, you're right. I'm going to say, though, that It has worked, it does work to do both those things at the same time. An I-10 and a credit check is something that happens. An I-10 and a background check, that happens. But for more detail into how it happens, we have someone else, Madam Chair, if you'll allow them to answer
Absolutely.
the sort of picky, more specific processes that are involved here.
Welcome to the committee. Please introduce yourself for the record.
Thank you. My name is Jessica Llagafroqui. I am the CEO of Hispanic Solutions Group. We are a service credits organization bounding and funding in Minnesota, Wisconsin, Texas, California. And my experience with people with item number, they can actually create credit. You can actually see their credit score. I think there is this misleading information right now about the landlords, they can't. Yes, they can't. There is a reseller. You can actually check the credit report through Equifax and TrustUnion. I am doing this every single day. And people with item number, they try to do the best in this country. They can actually create credit. They actually have credit. There is companies like American Express, Capital One, US Bank, Sunrise Bank, National Bank, they actually give credit to people with item number. And also, if the landlords here, they don't know, you can actually report the record of their rent. People with item, they try to build in their credit. They try to do the best here in this country. And the last thing they want to do is not to pay their debts. If the landlord, they are worried about, hey, why you are not paying your debts, or you're not paying your rent, they can actually report with Equifax and TrustUnion. It's not a big deal. I can even show them what is the reseller. They can check the credit report. Regarding the information, regarding the information, the criminal record, thanks God we have now in Minnesota driver license. With a driver license, you can actually update and see the credit record through Leases, Netsis. Again, I am working this for 20 years. I am doing 7 years. I take classes three times a week regarding consumer laws. And this is something probably a lot of landlords, a lot of people here, they don't know about it, but I am talking in my experience. And it's not risk at all. Actually, it's helping even the landlords because if they are able to report in the credit report, it's no risk to any loss. Again, if they are in the credit report, they don't want to show a negative information in the credit report. That is my experience. Thank you.
Thank you. Senator Draheim.
Thank you. And thank you for bringing the bill forward. I just had a couple questions. In my trade area, we have a lot of higher ed, like in your area. A lot of international students, and they seem to find apartments with ease, if you will. I think no different than anybody else. So I'm a little surprised that this is as big an issue as it is, and maybe Mankato is an anomaly, and maybe not. I don't know.
Or St. Cloud is special.
St. Cloud, I didn't know if St. Cloud even had a college yet. But
please keep it civil.
I know, sorry, Chair. I had three kind of questions on how this program is going to work. And, years ago, my company did property management. We had about 140 units. I didn't know this was an issue. I wasn't involved in the day-to-day stuff. I dealt with other things. So, one thing that most property owners or housing providers want you to do as you're managing that property is to do some kind of background check or credit report, whatever the nomenclature is. And what I don't know is, does that I-10 work in most of the software used in the industry? So my understanding, an I-10 is just like a social security number, except for it starts with a different number than most social security numbers. So people could identify them. I think they start with a 9. But it's the same number of digits, I believe, as a social security number. But so for Senator Lucero to do his job and do a background check for the people he's letting into his units, so he can make sure they're safe, no matter where they're from. Anybody would want to make sure that they're letting someone in with doing a little due diligence. So have you checked, do the main background credit score, whatever the right nomenclature is, do they work with I-10s?
Senator Putnam.
Thank you, Madam Chair. Thank you, Senator Draheim. So first, in terms of the question of international students, if you don't mind me addressing that just briefly, my friends here from St. Cloud, they have other places they want to be, but they're international students, and they knew I was presenting this bill, and they know it is a problem in St. Cloud specifically. Again, I can't testify to the scope of the issue, but I can say that there are individuals who are international students who struggle to find housing because of I-10s. But again, in all honesty, I can't testify to the scope of that. Now, in terms of the questions of software compatibility, I can say that I have been assured repeatedly, and it makes perfectly good sense to me, that you still can do the credit check, the background check, all those kinds of things, that accepting an I-10 for identification in no way compromises any of those activities.
Senator Draheim.
Thank you. I only have two more, so I'll make it short. Thank you, and thank you for your response, Senator Putnam. The next is banking. Have you checked with the lending institutions? I know years ago when we were involved in this industry, there were different groups that like to pay with cash. And since then, I get quizzed every time I bring cash into the bank to deposit it. And they want to know where the money's from. And I know there's limits on that. Have you talked to anybody in the banking industry to make sure that we're not opening up a can of worms for those housing providers here?
Senator Putnam.
Thank you, Madam Chair. Thank you, Senator Hammond. I have. I held a meeting with a group of bankers as soon as I was approached with this bill and first started learning. I had a meeting with a group of bankers, and they saw no issues whatsoever. Again, not an organization of bankers, but just local bankers in my community. And they initially expressed no reservations, and then they said they wanted to look into it and get back to me, and they sent me an email a week later and said, no problem.
And I'll just jump in for a second. Senator Draheim and our last testifier also said Capital One, American Express, Sunrise Bank, and Wells Fargo all routinely use I-10 numbers. Senator Draheim.
Thank you. My last question is enactment date. Are we going to give people times to I assume a lot of the applications are online. I don't know. One of the testifiers said it was just a switch on the back end. What is needed, and then what time frame are we going to give the housing providers to be compliant?
Senator Putnam.
Thank you, Madam Chair. Thank you, Senator Draheim. I think that's an excellent question. And I think that's something that will get ironed out over the next couple months as the bill is considered. And I hope that as a member of the Housing Committee, you keep raising that concern to make sure that it is flexible and appropriate when we pick a date.
Senator Draheim and Senator Putnam, I'd like to work with you on that to make sure it's leases moving forward from a specific date, whether that's August 1st or another date. Members, any final questions? All right. Senator Boldon moves that Senate File 3769 is recommended to pass and be referred to the Committee on Judiciary and Public Safety. All in favor, say aye. Aye. Opposed? The motion prevails. Senator Putnam, your bill is on the way. Thank you.
Thanks.
Senator Fateh. Welcome to the committee, Senator Fateh.
Thank you.
You'll be presenting Senate File 3571, and I believe you have an author's amendment.
Yes, I have an author's amendment and then an oral amendment, if that's okay.
Members around the table, that amendment is being passed out right now. Senator Fateh.
So yes, the 18th Amendment just makes some technical and substantive changes to the bill to get into the shape that we agreed to. So.
All right. Senator Fateh moves the author's amendment, the A3. All in favor? Aye. Aye. Opposed? The amendment is adopted. Senator Fateh, to your bill as amended.
Thank you, Madam Chair, and I'd like to also offer an oral amendment.
Senator Fateh.
Thank you. In subdivision 5, section 2.4, it says recovery under section 504B.321. It's supposed to be 504B.231. It's just a clerical error that we want to correct.
All right, members, we are looking at line 2.4 on the author's amendment. It should be 504B.231. All in favor of that oral amendment? Senator Lucero.
Thank you, Madam Chair. So I just want to be clear, we're amending the amendment, is that correct?
That's correct.
So should we possibly, or is it in order to reconsider the adoption of the amendment and offer the oral amendment to then amend the amendment as amended? Madam Chair, I'm just not familiar with the process of amending an amendment after it's been adopted.
Okay, members, we will reconsider the amendment with the oral amendment on it. So it is, we will be re-adopting the amendment we just adopted, or reconsidering it with the change on line 2.4 to read recovery under section 504B-231. Members, are we clear? All right, all in favor, say aye. Aye. Opposed? The amendment is adopted. That is to reconsider. Now we re-adopt it.
No, now we offer the oral.
Now you offer the oral amendment.
Yes, I'd like to offer the oral amendment under section 2.4, subdivision 5, section, line 2.4, just editing 504B.321 to say 504B.231.
Okay, and the oral amendment is offered by Senator Boldon. All in favor, members? Aye. Opposed? The oral amendment is adopted. And now adopting the full amendment as amended, moved by Senator Boldon. All in favor? Aye. Opposed? Senator Fateh, your bill is in the order that you requested. If you would go ahead with your presentation.
Sounds good. Thank you, Madam Chair. Senate File 3571 came following the hearing that this committee and the Higher Education Committee held in September regarding the delayed construction at the Identity Dinkytown apartment development. As you may remember, Identity is a new construction project that signed leases with student tenants to move in at the beginning of September when the U of M's fall semester started. Unfortunately, construction of this building fell severely behind schedule, and the property management company only informed tenants of these delays on August 2nd, one day after collecting the first month's rent, leaving renters scrambling. This situation highlighted a huge gap in Minnesota's housing laws. Tenants lack recourse when promised housing isn't available by the time of move-in. This can be a very dangerous situation for renters to be in, potentially leaving them without housing for an undetermined period of time. Senate File 3571 is intended to give renters choices when a crisis like this arises. In simple terms, it allows the renter to be placed in temporary housing by their landlord, receive a stipend to arrange their own short-term accommodations, or break their leases entirely. It also requires landlords to provide reasonable notice of move-in delays so tenants aren't scrambling to make new arrangements at the last second. I have two testifiers here today who can tell you a bit more about this bill and why it's needed. With your permission, Madam Chair, I'll turn it over to them.
Thank you very much, Senator Fateh. First up on the testifiers list, I have Ms. Sakardande. Thank you very much for coming. Please introduce yourself for the record and present your testimony.
Thank you, Chair Port and members of this committee. My name is Sia Sacredande, and I'm a student at the University of Minnesota Twin Cities. Last fall, I organized over 400 Identity Dinkytown tenants, family members, and UMN students to support the informational legislative hearing hosted jointly by this committee and the Higher Education Committee. Senate File 3571 would provide a solution to the concerns voiced by me and the affected students at that hearing, as new construction is prevalent in the state, especially around college campuses. The displacement of students in Identity Dinkytown caused financial and emotional hardship to the affected students. At the legislative hearing last September, UMN students testified to the inaccessibility of the payment options offered by Identity, the inconvenience of living accommodations compared to their hectic academic schedules, and how stuck they felt in the situation as Identity was not offering them a way out to pursue a better housing situation. As first-time tenants, student tenants are vulnerable to being taken advantage of financially, especially by out-of-state companies like the developers of Identity. Because of Identity's lack of communication and the construction being nowhere close to complete by the start of the school year, hundreds of tenants were forced to sign another lease and pay rent for another unit at a much higher rate than they would have gotten earlier in the year because Identity would not let them out of their leases. The option to be let out of a lease when the unit is not complete would restore the balance of power between tenants and landlords and would have prevented the financial burden faced by these tenants. The inaccessibility of the rent repayment option and the location of alternative housing provided by Identity, along with the lack of necessary living amenities like a kitchen or a laundry system, meant that students were paying hundreds of dollars out of their pocket. Many of these students had no family in the area to assist them and were paying for their leases with no other financial support. By guaranteeing the protections of alternative housing and rent abatement, your committee would ensure that tenants would not have to worry about what to do next when their landlord informs them of a construction delay. No other tenant in the state should have to go through what these students and their families had to go through at Identity Dinkytown. Tenants should not be forced to uphold their end of the contract for a unit they cannot even live in. Senate File 3571 would provide the necessary protections to tenants as new developments continue to pop up around the state and college campuses like the Twin Cities campus. I thank this committee for its commitment to protecting tenants, especially student tenants. Thank you.
Thank you for testimony. Ms. Jimenez, welcome to the committee. Please introduce yourself for the record and provide your testimony.
Thank you, Chair Port and committee members. My name is Shana Jimenez. I'm a staff attorney at the University of Minnesota Student Legal Service. I represent University of Minnesota Twin Cities students in housing and consumer cases. I'm here to testify in support of Senate File 3571 and answer any technical questions about the bill language. This bill is meant to help balance the power imbalance that exists in new construction leases. One thing that I teach students when I'm going over new leases, especially new construction leases, is buried in the 45-page lease is this new construction language. And let me tell you, all the risk is allocated towards the student renters. While Identity Dinkytown is one example, it is not the only example in recent memory where a corporate out-of-town landlord signs student leases and then promises a day that's to open and then misses it by several months. When this happens, our students are left without housing and are with slow and inadequate legal remedies. This measure is about risk allocation and setting minimum standards of what must be provided when a landlord cannot deliver occupancy by the start date of a lease. By codifying Senate File 3571, corporate out-of-town landlords will be forced to meaningfully consider when a property will open, instead of picking an aspirational date to lock renters into and offloading risk onto renters who start their year in leases with months of housing instability. Thank you.
Thank you, Ms. Jimenez. We have one final testifier, Mr. McDonough. Welcome to the committee, Mr. McDonough. Please introduce yourself for the record and provide your testimony.
Thank you, Madam Chair. My name is Larry McDonough, and I'm Senior Policy Attorney with Homeline, a tenant advocacy organization. We get thousands of calls each year from tenants, and it gives us a decent barometer of what's going on in terms of what's going wrong. I've also been a housing attorney for 40 years, and I've got about 11,000 former clients, mostly tenants, but also nonprofit landlords. And I've also been a landlord off and on myself. So I'm here to just say that this is not a student problem uniquely, that this is a problem that we see around the state. And to be honest, you know, the numbers of times this happens probably isn't huge, but the impact on tenants when it does happen is huge. And I didn't see this phenomenon 20 years ago. We can all drive around town, any town where we live, and we see new construction, and that's a good thing. Be honest, I don't find the new buildings that attractive, but that's just because I'm an old guy. But when there is new construction and it doesn't go on time, the risk should not fall solely on tenants. And they are, whether they're students or not, they have left their other places, and they're the ones that are in the lurch. When I've seen problems of units not being available 20 years ago, it wasn't this phenomenon. It was a slumlord or two who would say, I'm going to collect deposits from 5 people and then only let one of them in. But we have a law there to deal with that. We have a lockout statute that allows those other tenants to file a case and to deal with that. But this is a whole different phenomenon, and I just wanted you to know that it wasn't simply a student phenomenon.
Thank you, Mr. McDonough. Members, we'll go to questions. Senator Lucero.
Thank you, Madam Chair, and I appreciate this bill because the stories that we heard over the summer, the students that had to endure that certainly was tragic, and it was not something that they should have had to endure. A lease is a contract, and there's 2 parties to any contract. And when one party is not upholding their obligations to the contract, the other end of that should not have a disparity in terms of obligations to that contract. So again, I very much agree with what's happening here, but I do have a couple just clarifying questions to the bill author, or I guess any of the testifiers. So and myself and Senator Fateh had the opportunity briefly, an actual true elevator conversation in the elevator for a few seconds. And so, what we discussed was this actually goes beyond new construction. And so the definition, I'm just drawing members' attention to the definition then of new construction. It also includes any physical changes altering the use or occupancy of the dwelling units. So that's what I want to draw members' attention to. So as I'm envisioning this, the question would be, how would this language then apply to existing tenants? So there's very real applications that I've had to do where a bathroom, in a unit, in a single-family home, a bathroom, so there's multiple bathrooms in the home, but one of the bathrooms is rendered inoperable because of leaky water behind the tub, the shower, tub surround. There's mold forming, which required me to rip out the entire thing, right? So that bathroom is out of commission. And then that forced my tenants to alter the use or occupancy of the dwelling unit. They had to use other bathrooms or in the house. So in that scenario, I then get to the requirements then. And it says that you get into those 3 provisions that a tenant would be able to select from. So what is that the intent, or am I understanding what would happen when remodeling or renovation or fixing that would have an impact on an existing tenant, changing the use or occupancy?
Senator Fateh.
Yeah, thank you, Senator Lucero, and thank you, Madam Chair. So the intent is any time a student or a renter, I should say, or a tenant is not able to utilize the unit, if there's any delay for any reason, then there should be action for that. We know that, for example, during COVID, there were supply chain issues, and that delayed reconstruction, remodeling, things like that. And that's an example of a situation where that would occur. Do these situations cause situations where the renters are impacted longer than, say, a new unit being developed? Probably not, but it still does happen. But at the same time, I'll be happy to work with you on this language. This has one more stop, by the way, in housing, so in between, I can be happy to connect with you.
Thank you, Senator Fateh. Senator Lucero, I have a similar question, but I think it might be answered. Perhaps Council or Ms. Primo can look online, the end of line 1.8 and 1.9, where it says, will not be available for occupancy. To me, that seems like a required point of it. So if you're remodeling one bathroom in a unit, but the rest of the unit is available for occupancy and they can live there, it doesn't seem like this would come into play. This would be if you cannot occupy the unit. Just wondering if perhaps, Ms. Primo, if you could clarify if that's what I'm reading there.
Madam Chair and members, that is how I read it. I read that there are certain triggering events that have to happen before these options kick in. If there's some clarification that the committee or the author would like to explore, or if there's still some ambiguity, that's certainly fine as well.
Thank you. Senator Lucero.
Thank you, Madam Chair, and I appreciate that. So I would just draw members' attention back to the definition. So it says any physical change. So that's anything. It could be something very simple or larger. Altering the use. So there's altering the use of the dwelling unit. So it's not just the occupancy, it's altering the use of it. And then you can see there on line 1.6 is the word or. So it's use or occupancy. And that's where I'm focused here. So then if that condition is met, which would happen with the bathroom remodel, let's say there's a leaky toilet on the second level that leaks down, and for whatever, there's a bedroom below. Now it requires all the sheetrock to be torn out and the ceiling and replaced and whatever. Right now there's an alteration of the use of the bedroom on the first level that kicks off this, the rest of the language. And so that would then require one, it's very prescriptive. It's either options 1, 2, or 3 in terms of a remedy.
I disagree.
Go ahead. Okay.
I think that potentially kicks off it, but if it does not meet the second part of that sentence that says it will not be available for occupancy, then the rest of this.
And where is that? What line is that?
1.8 and 1.9. That the new construction must make the rental not available for occupancy in order for this.
By the move-in date. Okay, so then, Madam Chair, I would just draw, so occupancy by the move-in date, but what if they're already in? What if they're an existing tenant? The language here is a blending of two scenarios. It's a traditional new construction scenario where nobody's occupying it. And then you have another scenario where there's already occupants and now it's altering the use thereof. And now so I think there's confusion because it's blending these multiple scenarios together in the verbiage. I'll just submit that for Chair as members' consideration.
Senator Fateh?
Yeah, I just wanted to say that the intent was what you just laid out from 1.9, Madam Chair. No, first, thank you, Madam Chair. I think that was the intent of it. Also for 1.6, where it says use or occupancy, it was intended to refer towards the habitability of the unit, not just the availability of it. So that's for 1.6. So it just literally if the tenant is unable to be in the unit or occupy the unit.
Senator Draheim.
Thank you, Chair. And thank you for bringing the bill forward. I know it was a real challenge for those young kids to have to deal with this last year. I also had concerns about the definition. It's pretty broad, and I think that needs to be tightened up, my personal opinion, and maybe a little more clarification when the occupancy. So under Senator Lucero's example of a bathroom having to be redone, so if they had to leave because there wasn't a working bathroom, then I think there should be some accommodations. But if it's a 2 or 3 bath home, 2 probably in the vintage he's talking about, and they have another bathroom to use for a week or 10 days or whatever it is to fix, I think that's reasonable accommodations, but I don't think it spells it out. And I think we just need to tighten up the language before it moves on to judiciary, I assume, right? Is that where it's headed? And then on 2.7 and 2.8, and maybe this is a PREA question, but what the remedies available under this section are in addition to the other remedies available at equity or law. And I'm not up on that phrase. So if someone over here could help us out, that would be wonderful, Chair.
Ms. Primo.
Madam Chair and members, that language is often added to bills that create new remedies, new rights of action, in order to clarify that if there are current law actions, particularly in the common law, that this does not expressly take that right away, and instead is just one additional toolbox in the toolbox for a potential plaintiff to use. So it tries to preserve current law remedies as well.
Senator Draheim.
Thank you. And my lead-up question was going to be, what are the current remedies that these students could have faced in the example you guys gave earlier? Do we know those real quick?
Ms. Jimenez.
Yes, Chair Port and Senator Draheim. Students had a variety of legal measures at law, including like a lockout petition saying they couldn't enter the building, an emergency tenant remedies action, or a tenant remedies action. What we saw in those cases for remedies at law is that the first hearing is a couple weeks after the petition's filed, the next hearing's a couple weeks after that, and the trial's a couple months after that. During this time, maybe some people in some floors were able to get housing and some were not. So those were equities at law. Those were remedies at law. Equity, that might mean additional compensation. It could also mean it's more inclusive of non-statutory remedies.
Senator Draheim.
So my follow-up to that, Chair, would be, what is going to change in the time frame between what's already on statute, the three examples that were given, and then this new law?
Ms. Jimenez.
Chair Port and Senator Draheim, I think it clarifies a base level of what is allowed. There is always a fear by a renter that if they choose a remedy at law, that potentially any offer on the table could get taken away from them. And that would be something that I would advise someone and say, hey, a landlord isn't required to give you a daily rent credit. And if you try to make more than that at court, they're going to take that away. That's a possibility. They may not, but they may. So this sets a very baseline. It also clarifies what is reasonable, what is acceptable, because that varies somewhat on what a landlord is willing to provide out of what they consider to be the goodness of their heart.
Senator Draheim.
Thank you, Chair. So it really doesn't address the time frame issue, but it does give clarification what a reasonable action would be from a housing provider.
Ms. Jimenez.
Senator Port, Senator Draheim, I apologize. Another additional piece why it could speed up this process is it would clarify what the remedies are. In some litigation, when it's ambiguous, a party might seek to do some sort of like summary judgment measure, some sort of other alternative measure where they could get up to 90 days for a judge to make a legal decision, which could potentially push it out. This would make it so that would be much more difficult to continue to run the clock in that way.
Senator Draheim.
My last comment would be the enactment date. I think August is a little quick, but that's minor compared to my other concerns. So thank you.
Senator Lucero.
Thank you, Madam Chair. And just one other quick question that I have on line 1.15. It says that payment by check or by cash or check. So it's two options. So does that eliminate ACH, wire, or other electronic funds transfer? It looks like it's very, very specific to either cash or check.
Senator Fateh or Ms. Jimenez?
Thank you, Madam Chair, and thank you, Senator Lucero. I'm open to expanding the different forms of payment and having that conversation with you.
Senator Lucero.
Thank you, Madam Chair. So yeah, I just throwing it out there because, again, words mean things. And if it says cash or check, I know in this day and age, digital currency is how many payments are made. So didn't want to eliminate that from consideration. Thank you.
Members, any other questions? Senator Fateh, I want to thank you for bringing this bill and your testifiers as well. The stories that we heard over the summer were certainly horrifying, and I can't imagine the stress that added to those renters' lives. And I appreciate Mr. McDonough's addition that this is not just a student problem, that it affects renters of all kinds. Senator Fateh, I encourage you to continue to work with housing members, and we'll make ourselves available to fine-tune this as you move on to judiciary. But Senator Boldon moves that Senate File 3571 as amended be recommended to pass and referred to the Committee on Judiciary and Public Safety. All in favor, say aye. Aye. Opposed? The motion prevails. Senator Fateh, you are on your way to judiciary. Thank you very much.
Thank you, Madam Chair.
And the final bill on our schedule today is Senator Kupec's bill, Senate File 3807. Welcome to the committee, Senator Kupec.
Thank you. I think this is my first time in front of the Housing Committee, so.
We're very kind here.
Check another one off the list, I guess, here. So, yes, I have Senate File 3807. This is a bill relating to housing and requiring landlords to test for radon in those houses. So radon is a serious public health concern here in Minnesota. The average radon level in Minnesota is more than 3 times the U.S. average radon level. This is due to our geology and how homes are operated here in the state. Minnesota homes are closed up or heated most of the year, which can result in higher levels of radon. In Minnesota, more than 2 in 5 homes have radon levels that pose a significant health risk. Radon is the #1 cause of lung cancer for non-smokers and the second leading cause of lung cancer among smokers. Your risk for cancer increases with higher levels of radon and longer periods of exposure. If you smoke, the combined risk of smoking and radon exposure is much higher. Why I am bringing this bill forward comes from some constituents. So over the last fall, this is kind of the theme, I guess, today with college students. We had some college students in Moorhead, Concordia students who moved into a house off campus. We have a lot of little ramblers that have been converted into housing, and of course they put bedrooms down in the basement with eased windows, and it was either the student or their parents decided, you know what, if you're going to be living down in that basement area in particular, maybe we ought to test for the radon levels in that house. And when they did, they were much significantly higher than the levels that are suggested by the EPA. And so those students brought that to the attention of the landlord, and unfortunately the landlord said, well, you've signed a lease, you're out of luck. And so those students, as school was beginning with no other options, moved on to on-campus housing, but then we're still paying the rent for off-campus housing as well as paying for on-campus housing. And so this was brought to my attention that maybe there ought to be something with regards to radon in terms of safety in housing, and whether you should just know that as a disclosure going in. So that is why I'm bringing this bill forward.
Thank you, Senator Kupec. I have one testifier on the list, Jennifer Spadini. Please introduce yourself for the record again and present your testimony.
Madam Chair, members of the committee, my name is Jennifer Spadini. I own and operate a property management company providing housing throughout the Twin Cities area. I'm here today on behalf of the Minnesota Multi-Housing Association to raise our concerns on Senate File 3807, the radon testing bill. Professional radon testing is an expensive requirement. In multi-housing, testing must already be conducted when a property is purchased and during refinancing. We believe these and other situations where a property may test for radon should meet the requirements of the proposal. However, no such language is provided. Additionally, continued testing on a building which has already been mitigated or remediated would be duplicative and add unnecessary costs. Buildings which sit atop parking garages already must have ventilation systems and would effectively have already mitigated radon concerns. We believe these situations should be considered for an exemption from the proposal's requirement for continued testing. The bill does not propose specifics for how many tests must be completed and where the tests must be conducted. We believe this could range from 1 test in a building to 1 in each room. We believe more is needed in the proposal to provide guidance. Finally, a radon disclosure is most relevant to those who live on the lowest floors. Disclosure to an individual who, for example, would be located on the 7th floor when the apartment does not have a common area on the 1st floor would appear to be unnecessary and should also be considered for an exemption from the statute. Thank you, Madam Chair and committee members, for the opportunity to provide these concerns.
Thank you for your testimony. Members, we'll go to questions. Senator Housley.
Thank you, Madam Chair, and thank you, Senator Kupec. I agree that radon's been the topic of discussion for many, many years, and being a realtor in disclosing that to your clients when they're looking at homes is extremely important. But what I am really worried about is the trickle-down cost to the students or the renter on what it's going to cost them. When you just heard the building owner now say it is very costly, and especially to do it every 3 years, that will pass down to, the prospective renter. I just spent the last 2 months looking for an apartment for my daughter, and it's hard to afford right now. And so adding this cost on, I think it's a little much, especially when I was watching Wheel of Fortune last night, and during it, the Minnesota Department of Health actually advertises that you can get a radon test at mn.radon.com for $13. And so even our Department of Health is suggesting go to the Minnesota Department of Health because they sell them there for $13. I think that somehow, if we can make this not so expensive for the person who wants to rent, who's just looking for a place to call home. So that's my worry with it. My second worry is December 1st is pretty quick. I don't even think we have enough radon mitigators to do the testing by that time. And if we're going to have this huge rush to get all of our buildings tested, I mean, the price is going to go up even further. So I think, one, I would suggest moving the date back to maybe January 1st, 2025, or even a little bit later, or continue to look at some of these issues. Because I don't know, a radon test is going to be $300 for each of these buildings every 3 years. I think it's just going to trickle down to the person who's renting. Thank you.
Senator Kupec.
Sure, and thank you for that. And so next week, I am meeting with the Apartment Owners Association there. And so we've got some of the discussions, and there are a couple of changes. And you're right, I think the 3-year window, actually, I was supposed to have a meeting yesterday with the Department of Health, but it was President's Day, so they were all off. But it does seem like the 5-year is actually what they are recommending. So that is a change that I plan on making to the bill and offering that at the next stop to make that an amendment and stretch it out. But I do think there are a few of those exceptions that they just brought up here that I am totally open to and making that affordable. Really what we're trying to get at is just making sure that people's health is protected. And I think, the best way we can find that balance moving forward, I am open to that.
Senator Housley.
Thank you, Madam Chair. Thank you, Senator Kupec. I'm glad you're taking those meetings, and they all had President's Day off, and here we were, still working. I still can't figure that out. I missed one Monday because I didn't think we worked on President's Day. I mean, I'd be willing to make the oral amendment to change that to 5 right now if you're open to it.
I am more than happy to take that amendment right now. We can do it.
Okay. Thank you, Madam Chair. I would like to make an oral amendment to
1.15?
line 1.15 to change once every 3 years to once every 5 years.
Ms. Painter, if you can read the oral amendment as it will be offered.
Okay. Madam Chair and members, page 1, line 15, strike 3 and insert 5.
Members, any questions on the amendment? right, Senator Housley offers the oral amendment. All in favor, say aye. Aye. Opposed? The amendment is adopted. Senator Housley?
That's it for right now, Madam Chair. Thank you.
Thank you. Senator Boldon?
Thank you, Madam Chair. Thank you, Senator Kupec, for bringing this bill. I appreciate the health impacts of this and especially appreciate the disclosure to tenants, because it's one thing for the homeowner landlord to have this information, but it's an entirely different and important thing for the tenants and potential tenants to have this information as well. I have a question about mitigation, which is lines 2.13 to 2.16, just because I'm not familiar with this process. So it states that a radon mitigation professional who is licensed under that section must perform the mitigation. Is the outcome of mitigation always that the radon rates are below the recommended EPA level? Like, will that always be the outcome of the mitigation?
Senator Kupec?
Madam Chair, Senator Boldon, as far as my understanding it is that it would lower it below that level is what the mitigation would do.
Senator Boldon? Oh, Senator Drahan?
If I could address that just a little bit. In my experience, that there's two types of systems they put in. One is a passive system. So they seal up the concrete on the floor. They usually put a basket in and they seal it up, and then they pipe it up through the roof. It has to be, I think, 8 feet above grade. And then the other system, they put a little blower motor and actually suck the air out of the bottom. And I have had houses where I've had to put more than one unit in to get the levels below in my area. We have a ton of disclosures and pamphlets available from the real estate realtor side. And I have a bunch of questions. I'll be quiet. Thank you for indulging me. So it is possible that the system would not work once they install it. And then that would be another cost to have that retested if it doesn't meet the requirements.
Senator Boldon?
Thank you, Madam Chair. And I guess the reason I'm asking is because, in the end, I want to be sure we get to a point where it's safe. And so I don't know if this language, as it is, always gets to that point. Just raising the question. Thank you, Madam Chair.
Senator Draheim?
Thank you. Senator Housley had her hand up also, just to make sure you saw it. Does this bill have a fiscal note coming?
Senator Kupec?
I do not believe that it does, but I could defer to that. I mean, obviously, there is some cost, obviously, to the Department of Housing on that.
Mr. Mueller?
Madam Chair and Senator Draheim, I have requested a fiscal note for this bill. I believe it would probably have a cost to the Department of Health. So when it travels over there, I think the fiscal note should be ready by that time when it gets heard in that committee.
Senator Draheim?
Thank you. I would assume it would, and I just wanted to make sure everybody aware of that I think there will be some costs associated as drafted. And I think there are ways we could accomplish the same thing and phase it in over time where we could reduce that fiscal note or eliminate it. The time frame, once again, it's been a common theme today. The December time frame, and I don't know what the Moorhead market is like compared to where I live in south central Minnesota. But there really isn't that many licensed radon testers out there or installers out there. So have you thought about maybe moving that date back or phasing it in over time with different stages to help alleviate that backlog that I think if this goes through that there would be?
Senator Kupec?
Thank you, Madam Chair. Thanks, Senator Draheim. Yeah, I'm totally open to working with that to make that, a much whatever is more doable by talking to the industry. So sure.
Senator Draheim?
I could go on for days, Chair. My biggest questions have to do what type of properties will need to be tested. So, one real popular type of property is a slab on grade. So, something built maybe for older people or people with mobility issues where they don't have to climb stairs or go in a basement. And normally, we don't worry about structures that don't have a basement. Kind of like the testifier brought up about a lot of the apartment buildings having a garage system, parking garage underneath, and then all the units are above, and then they have makeup air, just like our parking garage does here in this very building right now. So I think we need to define what buildings, what type of buildings, and what case they would need to be tested. And then if you have a huge, huge building, the way this is drafted, I could see the MDH coming and make you do every room. And that would cost tens of thousands of dollars to at least for a landlord. So I think, I love the concept. I think we're all worried about health, but I think we need to massage it a little bit is what I'm getting at. I think there are a lot of different types of buildings and some, you know, below grade. It makes sense to have them tested. But I'm on the 3rd floor in my apartment up here in St. Paul. I don't think I need a test. My parking garage has ventilation, you know, automatic kicks in and kicks out, just like this building does. So I think we need some exemptions, and I hope the author will work with the Multi-Housing Association and other groups to try to clarify the what-ifs. So I'll quit there, Chair. Thank you.
Thank you, Senator Draheim. And I wanted to let members of the committee know I am going to ask for this bill back after it goes to HHS. So we will see it again before the end of the year. Senator Lucero.
Thank you, Madam Chair. And along those same lines, I guess to the bill author, the scenario that he brought up was a rambler. So obviously below grade 1 level, presumably. What about the scenarios where it is an unfinished space, such as a dirt basement, a home that's 100 years old? Would you expect that to be, what do you envision is the mitigation effort involved in a dirt cellar type basement that's not livable?
Senator Kupec.
Sure. I think in that case, I think you're really concerned about what is the radon level up where the living is occurring, that it's there. And so that, if we want to spell that out a little bit clearer in the bill where that is, whether there are bedrooms involved, clearly the dirt basement, you're not spending a lot of time down there, but if that is coming up into the upper levels, then we should test up there. That's where you want to test.
Senator Lucero.
Thank you, Madam Chair. So I won't ask a series of questions. I'll just go from my experience here. Again, I'm very concerned about cost being put down to the tenants. Right now, housing market, cost of living is exploding. And in the scenarios, in my experience, 100-year-old homes, dirt basements, I have had, when I've purchased homes or when I've sold homes with dirt basements, there's a series of disclosures. And so I guess I would submit, maybe you consider striking the mitigation and focus on the disclosure requirements, because in a dirt basement, I'm not sure of the active systems, but at least for the passive system, a vacuum needs to be created. So you have one of two options. You either bring concrete in, you have to bust open the foundation to get concrete, or you bring in a series of wheelbarrows, it depends how you can do it, to get the concrete into the basement, to fill it in, to create a gap, a seal, so that the PVC can go in there and have that passive ventilation. Or I have had a licensed professional in the scenario of a house I was selling say, in the absence of concrete, you have to put poly down. So you have to create a vacuum by laying poly across all of the dirt, sealing it to the fieldstone foundation along the walls, which is not smooth in any degree. And then if that seal ever breaks, you don't have a vacuum, and therefore the passive, it doesn't work. And your bill doesn't allow for that. And by the way, that was, I think, like $5,000 or $6,000 10-ish years ago for what I'm describing. And so either you're going to render that house not financially feasible to be available for rent, or you're going to significantly raise the cost. And so again, I just submit that you might want, 90 days, Madam Chair, do you know, to the bill author, do you know how many licensed radon professionals there are in Minnesota?
Senator Kupec.
I do not, but when I Googled it, I got a lot, but I don't know. For the testing, sure. And that is the 90-day, I will say, is one of the areas too that is probably short with other conversations I've had since the bill was drafted. So I'm also amenable to extending the 90 days out. I realize that is a short time frame, so.
Senator Lucero.
Thank you. Okay, and again, I just want to stress, in these scenarios where you don't have livable space, it isn't financially practical to bring in a single-family home that's renting for $1,500 to spend $10,000 to bring in and create a slab in the basement that nobody's living in, and or to try to bring that poly down there and create that vacuum. It's not going to work. And so I strongly urge you to consider that the one-size-fits-all isn't going to work with all these slab-on grades. In other scenarios, what if a system already has the mitigation system in there, active or passive? Do you still require the testing every 3 or 5 years? Right? If a system's already in, do you still require that testing? So there's a whole host of property types, units that this definitely needs further consideration. So thank you, Madam Chair.
Senator Kupec, thank you for bringing this bill. I think it's really important that Minnesotans who are renting have safe places to live, just like people who buy homes and are able to get disclosures of this type. I would like to move this bill today to HHS because it has to go to HHS and to Judiciary. I am asking for it back after that, and I'd like to work with you on this, but I do think there's also in some of these sections under the Health Committee where you're going next, it does describe specifically the types of buildings where this testing is required. So I believe that's already in statute, and that committee will be able to help navigate that a little bit more clearly. Happy to work with you from that. Senator Housley, I think you had one more question too.
Thank you, Madam Chair. As I was sitting here rereading this and thinking, I'm just hoping maybe the senator would be amenable to maybe pushing that date back a little, being that MDH is required to produce the document, radon and rental properties, by December 1st, 2024. And that's also the date that the landlords will have to provide the tenants with a copy of that publication. And I'm just a little worried that maybe if MDH doesn't get it done by then, it's kind of a gray area. What do we do? I'm wondering if maybe you'd be open to pushing that date on line 2.27 to August 1st, 2025. That way students coming back to school would be able to see the report from the apartment building in time for getting their apartment for school, and gives time, there's a window between when MDH has to publish the document and apartment owners will know what it says.
Senator Housley, I wonder if I can offer a different suggestion.
Yeah, and I have a different also, Chair. So can I offer mine also? Instead of
Absolutely.
maybe just picking a random date.
Yes.
I'll confer with MDH and see what is doable for them, and then consider that going forward. But if it's not doable in that short amount of time, then absolutely I don't want to burden them with that.
That's great, Senator Kupec. I was going to suggest to Senator Housley that I agree that's likely too early.
Right.
If it has to come through this committee or the Health Committee, there may be no budget for it at all this year anyway. We'll have to see budget targets. I'm happy to work with you to keep an eye on this, and by the time it comes back to our committee, make sure it has a date that works. But I think until we have a fiscal note, it's pretty difficult to say when MDH will be able to be ready. And I wonder if we can hold off for now with my agreement that we will make sure it's a date that's feasible.
Thank you, Madam Chair, and I'm so glad you'll be getting the bill back for us. Thank you.
Absolutely. Senator Draheim.
Just confirm that roll call vote we had. Do we need to raise 3 hands?
Yes. Roll call?
For the bill we did earlier.
Thank you.
Yeah, thank you. Just want to make sure.
Any other questions on this bill? All right. Senator Boldon moves that Senate File 3807 as amended be recommended to pass and referred to the Committee on Health and Human Services. All in favor say aye. Aye. Opposed? The motion prevails. Senator Kupec, your bill is on the way.
Thank you.
Members, I am delighted that we finished on time today. Good work. We are planning to meet on Thursday to take up 5 bills. However, we are also advised that floor session may go long and our committee may be delayed or potentially canceled. So we are holding Friday at 12:30 if floor goes long and our committee gets canceled. We are at the end of our agenda today, and we are adjourned.